This on,
Started, call the meeting to order. Izzy, would you call the meeting of March the 17th? Roll call, please.
Jenny Anderson. Here. Dale Blanton.
Here.
Linda Dillon.
Here.
Frank Manoldi.
Here.
Rodolfo Barrientos.
The introduction to the code compliance meeting. Order. Good evening. This is the meeting of the Village of Biscayne Park Code Compliance Board. The board is authorized pursuant to Chapter 14 of the Village's Land Development Code to ensure compliance with the Village's Code of Ordinances. The members of the board are citizens and residents of the Village of Biscayne Park. We volunteer our time and are not paid for our services. The purpose of each meeting is to give any alleged violators the opportunity to contest the decision of the code compliance officer, which resulted in the issuance of a notice of violation, and to determine whether a violation of the village's code has occurred or is occurring. We are not authorized to dismiss violations based on hardships, ignorance, or the fact that others may be guilty of the same violation. These hearings are conducted in a quasi-judicial manner. Our responsibility is to act much like a judge in a court, and this is to hear cases presented by the village's code compliance officers and to hear contradictory arguments presented by the alleged violators. We are not authorized to change the code. The village commission is solely authorized to enact and revise codes. Conversely, neither the commission nor the village manager have the authority to overrule the findings of the board. Pursuant to Chapter 162 of the Florida statutes, orders of the board can only be appealed to the Circuit Court of Miami-Dade County. We are authorized to assess and order a payment of civil penalties, to issue orders having the force of the law, to command whatever steps are necessary to bring the violation into compliance, and to assess administrative costs. If you are found guilty of the civil violation charge, you will be assessed an administrative fee of a dollar amount. In order to make a finding upholding the code compliance officer's decision, we must find that there is substantial competent evidence that the named violator was responsible for a violation of the relevant section of the codes as charged. The hearing will proceed in the order of the docket. The village will first present its case, and the board may request clarifications to fully understand the case. When you address the board, please state your name, your relationship to the property, and state whether you're contesting the violation, in which you will then have the opportunity to present your case.
Side.
All documentary evidence presented by the parties must be submitted for placement in the hearing file. No documentary evidence will be considered unless the alleged violator or code compliance officer submits a copy for the hearing file. Each party shall have the right to call and examine witnesses, to introduce exhibits, to cross-examine opposing witnesses on any matter relevant to the issues, even though the matter was not covered in the direct examination, to impeach any witness regardless of which party first called them to testify, and to rebut the evidence against him. If you intend to address the board and have not signed in, please sign in at this time. Anyone wishing to address the board, please stand and raise your right hand so you may be sworn in. You're reminded that the board is a quasi-judicial board, and giving false testimony can be penalized. So with that, I don't think you necessarily have to stand, but if you just raise your right hand, if anybody's going to be testifying, do you swear and affirm that the testimony you're about to give is the truth and all?
Okay, we're gonna start with agenda item 5A. case EEN 220019, property address 11703 Northeast 11th Place. Property owner Charles Michael LaFruz. And this was regarding the failure to remove a bamboo fencing. The violation was observed January 18, 2022. A courtesy notice was issued, and a notice of violation was issued on January 31st, 2022. Additional documentation was located at initial hearing. Backup includes a final building inspection.
And on the final building inspection, what was that? Would you like to elaborate, please?
Yes. Yeah, on the last, that's the last page, or on the last page, 5 to up, it was the violation, or the fence in question was inspected and a final was issued on 7/17/2013 by Inspector Salvatore Anis. We did find that, and it was actually, we have copies, you guys have copies that it passed inspection.
Right. And so just to refresh our memory, our last month, we had, I believe, entered a notice of violation.
Yes.
And assessed a, what was it?
It was 100.
$75 fine and $75 fine and $25 day fine. I'll commence on the 5th of March.
Okay. So does anyone have any questions?
Yeah, comments, actually. Okay, just a brief timeline. If you notice, P and Z turned down the original request for chain link on the 17th of June of 2013. Wood was approved. On July 13th, the code officer at that point issued a courtesy notice instructing that that bamboo be taken down within 5 days. Now, in a piece of irony, 4 days later, there's a signed final permit. That permit is listed for a wood fence. If in fact the building inspector was at the property, he would have seen chain link covered with bamboo. Now, there's also, which would go against the courtesy, the courtesy notice that it was issued 4 days earlier. Now, bear with me a minute. There's an interesting Florida statute, 5-104.11. The building official is hereby authorized and directed to enforce the provisions of this code. The building official is further authorized to render interpretations of this code which are consistent with its spirit and purpose. Such interpretations, policies, and procedures shall be in compliance with the intent and purpose of the code and shall not have the effect of waiving requirements specifically provided for in this code. Our code simply doesn't allow for what was put up. So it would appear that the building official did not have the authority to override our code.
Yeah, I get my primary thought on this, I guess, is kind of a what purpose does finalizing and inspecting a permit serve if it's not the okay? I mean, to me, that's what it really implies.
I'm thinking along the same train of thought is, as a resident, if I received a final permit, I would expect my paid official to have approved it. I understand this, and that may be true, but if we didn't have any legal advice coming forward.
Since
attorney or
we
something,
have conflicting information here, I would feel much better if we move this on to ask the attorney to weigh in on this. I think this is something that we have conflicting information. We have the Florida statute, which says something, and we have the property owner with a signed permit, even though it was a signed permit for something that didn't exist. So I would like to see the attorney's interpretation. I'd certainly feel much better about whatever decision we made if we knew it fit the proper legal channels.
I think the village inspector made a mistake. But I also think that the homeowner made a mistake in terms of having a permit that, or requesting that it be wood, and it turned out to be bamboo, which is not allowed. So for me, they sort of cancel each other out. And I think that we had a case similar in February where we allowed the homeowner to keep the fence until it got to be 50% deteriorated. And then they were required to remove it and not replace it with bamboo. And that would be something I would suggest that we do consistency and do it the same way.
That's very true. On that case, it was the code enforcement officer that had
Correct.
told the resident, and it was in writing that the resident had from the code enforcement officer.
That was different in the sense that she approved bamboo.
Well, but
This is wood,
this was approved by our our official.
something completely different. It's chain link covered in bamboo
I don't think,
versus wood.
I don't think so. I think the official made a mistake. But that's okay.
Any
Rodolfo?
Wondering
Well, the permit was for a wood fence. Bamboo fence that's installed over a chain link fence. And in lieu of the wood, but it was also, the permit was finalized at the hearing that in February, I believe. The resident didn't have the permit in hand, and we didn't have it in our records at the time. Since then, we have the finalized permit was located, and it's signed off by the inspector at the time. Even though it may have been a bamboo fence, it was finalized.
You would think so, wouldn't you? And again, I go back to the Florida statute, which appears to be saying that the code officer, the building official can't just misinterpret, his misinterpretation of our code doesn't make it right. We have Florida statutes, and that's the difference. We didn't have this information back when that other case was heard.
But how does this, I mean, as a homeowner here, and you do a project, you apply for a permit, you get a permit, you do a job. In this case, the job may not have been what you proposed,
You're right.
but
Fair comment.
Biscayne Park approved it. As a homeowner, I would consider that to be the end of it. And if there was a mistake made by Biscayne Park, that's their problem. I mean, if I'm sitting in this situation, I would have a hard time with this. And I also can see the point of, if this is where the two sides are both pretty substantial, to let the attorney weigh in on this, because I think this is really a difficult one.
Would anybody, sir, would you like to say
Yes.
anything?
We didn't forget.
So I am Michael LaCruz, owner of the property. Do you have a copy of the permit?
Only
Yeah.
everyone does.
Or, well, the signed inspection anyway.
By the inspection, you mean the inspection.
But not, you don't have the permit itself?
Permit. Yeah,
It's right here.
yeah.
Right. You don't have the, I have a copy of the permit. With the,
For the 6-foot wood fence.
shows the chain link being relocated. What happens? I came to this very meeting, whatever, 8 years ago. It was first denied. I came here, explained what I was doing, discussed the bamboo with this whole committee, and it was approved. The notes of the meeting don't tell you, don't mention the bamboo, but after the meeting, then the permit was approved, and it was approved exactly the way you see it built, and exactly the way the inspector inspected it and approved it. So,
Just for the record, that would have been the P and Z committee, not this committee.
okay, no, that's right. No, you're absolutely right. It's a planning and zoning committee. It was a meeting for planning and zoning. Was not code enforcement.
It says wood.
And the violation that you're talking about, I was never aware of that violation in the middle of inspecting the permit. I didn't get
Yeah, I
that.
can show you, sir, if you want to see it.
I'm sure you have a record of it. I'm sure you didn't make that up. I
You wanna
believe,
come see it? I got
no,
it.
I believe you, but I was not aware of it. I never heard of that. But following the meeting, that
Code officer.
those notes and everything's on there. The wood is bamboo. That's what it is. And it was inspected and done, So it's just baffling for me to be talking about this 8 years later.
It's wood fence. Doesn't say chain link covered with bamboo.
It has bamboo in the, not on the cover, in the back. It shows you.
Well, anything else you'd like to add, sir? Otherwise, we're gonna discuss.
No, that's pretty much it.
Well, my thinking is that I have a finalized permit. I would, as a resident, think that I have come into compliance and it's been finalized. I don't know if there was a misunderstanding between wood and bamboo. And I would entertain, I think that Linda had a good suggestion coming into a case that we had last in February also that was somewhat similar in nature. In that it was a bamboo placed over an existing chain link fence. I believe that wasn't even a permit. It was just a suggestion by the resident, and the code officer at the time agreed with it, and that they had to remove slats out of the fence.
Well, the difference to me is, like I said, it actually stated bamboo. It was said that resident could keep bamboo. This not only has bamboo, it has chain link, both of which were turned down. Well, I shouldn't say both of which, certainly the chain link was turned down by P and Z. That's in the notes. Yes.
Well, I like, again, kind of using our own recent history of one idea with this is when it's time for it to be replaced, that it cannot be replaced with the same. I certainly lean toward a finalized permit, even if it's mistaken being the fault of Biscayne Park. And that ends with it being the fault of Biscayne Park. But I would certainly feel comfortable too if we have to punt this to the attorney, because it's possible that there's more to it.
That's my feeling. I'm not saying hold to our findings. I'm saying let's get a higher authority. So that to me, I would have a much greater comfort level, whichever way we went, because this is a little technical. And to be fair to the property owner and fair to the village, I really feel very strongly that we need the attorney's advice.
So would you like to make a motion? And
Okay.
all right.
Sure. In case EEN 22-0019, in light of new evidence that's been presented, I would like to ask that the code officer forwards this on to the attorney for attorney's interpretation, and then bring it back in front of us next month.
But with regards to the current fine and
That stays in abeyance until we get a ruling.
so that.
I'm sorry,
that- that-
yes.
You're making that in the motion.
Correct,
It's in abeyance.
Yes.
Would you like to read it?
My motion would be that in light of the new evidence that's been presented, we forward this on to the attorney for the attorney's interpretation. It gets brought back at next month's meeting, and until then, any fines are in abeyance. There is no accumulation.
I would second that for discussion. So if I may restate the motion, it's to motion is to hold the fine and
No
the
fine,
daily
right.
assessment in abeyance
Correct.
and forward it to
And then bring it back next month, that we can hear it again.
first and second. Discussion.
Do we want to, I don't know, what level of detail we want to provide the attorney? It's what we discussed, or if we would just want to hand it to him cold.
Well, yeah, we've taped this, am I right? It's on tape? Yeah.
Okay, so he can see what we've discussed.
That's a very good idea.
Yeah, there's definitely some nuances that would be good
Sure.
to appreciate.
I think that's a good idea. Thank God for tape.
And the important thing is that there would be no, the fine and the daily assessments are in
Nothing, right,
abeyance
it's in abeyance.
until
We don't go forward with that until
It's just,
we get.
everything's on hold.
show.
Can I just give this to, give this as evidence?
Sure,
Since
yes.
you
sir.
don't have the full, because it's with the survey and there's notes on here about exactly what I did.
Sure, if you'd like to enter that.
Take a picture, that's fine.
So that's your copy. So you want with.
I have another copy. You can have it.
Got it.
I have another copy.
Oh, that's noted on the survey.
It is.
Noted on the survey. To existing change.
So shall we call this to a vote? All those in favor of the motion?
Aye.
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 Aye. So Sir, we're just going to give the findings of the attorney. Right now, there is no fine, there
There's
is no,
fine, nothing, there's no compliance date at this point. We just feel better in light of getting new information so that we don't compound problems. Thank you.
Would it be possible?
We'll know
think
that after the attorney,
That would be
af-
with that
after
additional
the
question.
attorney weighs in, then we'll be able to better make that determination. That was why I felt so strongly about it. In fairness to everybody. We don't want to compound problems.
helps us in the future with other cases that may have similar issues.
Exactly, and it will, I mean, inevitably.
I'm greatly appreciative of the fact that you were able to locate the survey. Finalize the thing. We'll have some better information. It'll be short and sweet, and we can put you at the top, and it's an issue we can move.
Old business.
Thank you.
Sir.
Thank you.
Is there anything else anybody would like to discuss?
I'd
Or
like to talk about one thing, but
are we finished with this? If you'd
Yeah,
like
with
to
this
leave,
case
you're
is it.
welcome to stay. Thank you.
That's it.
Yes, sir. Thank you, sir. Good. And so we'll add this for discussion, for a miscellaneous item to the agenda.
it's only something, as I mentioned to some of you, that in doing a lean search, we came across these two violations that were still open on a property, and it turned out it was not the correct property. But now that I think about it, this board ruled on those two issues, even if it wasn't the right property. Should we bring it back and make it official that it was done in error and close it properly rather than just close it?
I
would think.
I
I
think
would
we
think
should,
so.
right?
I just think to make it right.
To make it right.
be Correct,
I-
everything legally, I would.
I think so too. Rather than just.
Linda, good idea.
I think we should do that.
I agree, and it might be another thing that we may also just want to front that attorney to
Mhm.
get his
So we get the proper
on issue.
procedure.
But I would think if we made a ruling, even though it may have been, you said it was several years ago.
Yeah, it was 2017, I think, 17 or
2017,
18.
And it's been going this long that we would like to close it out properly.
And I think it's, what we saw tonight was, it wasn't at all funny, but a comedy of errors. Here you have, on the 13th, a courtesy notice, take it down. 4 days later, you have a final permit. I mean, this is stuff you can't make up. So to me, if we have these sort of situations, we've got to formally fix them, not just, okay, it's the wrong place, we don't worry about it. I think that's really crucial.
And I'm glad you had that information that you had for the code, because presented with the information, with the signed off permit, a finalized permit, I would, and was inclined to dismiss it, or
Naturally.
because
Absolutely.
as a resident, I would have an issue.
I'd be ticked off.
No, I,
Yeah.
I would have said the same thing until that, which seems, now, I didn't go to law school, that's why I wanted the attorney to read it, which seems to be saying, if they misinterpret something, the code is still the code, but that's just my opinion. I'm putting up the law school graduate's opinion as to what the right way to go, so that we don't compound it.
Can I put a wager on this? I'd like to make a wager that the attorney is going to say that we screwed up and it's our problem and need
Well,
to
we'll see.
discuss it.
Whatever he says, he says.
A buck. I'll bet you a dollar.
All bets are not authorized in here.
This attorney could say one thing and other attorneys will say.
It's
something
true
else.
too.
So whatever he says, it is what it is.
So
Okay.
I make a motion, we adjourn.
I'll second. All in favor?
Aye.
Aye.
Thank you.